You may be familiar with the late, great Heath Ledger. He was an actor who unfortunately passed away at a very young age in the midst of his acting career, just as things seemed to be taking off for him. One thing you may not be familiar with, though, is the unfortunate legal battle that ensued as he passed away. Unfortunately, he had made a will prior to being married with a 2 year old and didn't leave either his wife or daughter in the will. Unfortunately for their family, they had to go through this process while also in the grieving process. Now, there is belief that they were made whole by the family of Heath Ledger and that things were handled. However, it represents a larger issue that if you're not carefully planning your finances and specifically your estate planning, at your time when you're called, you may leave behind a financial mess and a legal battle for your loved ones. The purpose of today is to actually talk through some of the different things that you can make sure that you do and have a better understanding of how beneficiary designations work so that you can make sure when your time is called, your family is in the best position possible to move forward. If we not yet met, my name is Danny Cieniewicz. I'm a CFP professional from Hyperion Financial. Something that I've noticed that a lot of retirees and folks that we work with generally don't like talking about is their passing and how they plan to leave assets to the next generation or to their spouse or to whomever they're planning to leave it to. Oftentimes, death is not something that we enjoy talking about, and it's understandable why. However, it is a fact of life, and making sure that you have plans for your passing and how your assets will then be distributed is of the utmost importance. People tend to spend a good amount of time worrying about their last will and testament, along with their living wills or trusts that they may have in place, making sure that they're able to pass things to the next generation that they would like to do so. And it's important to make sure that you have that. There are many items that a individual possess that will pass by trust. Making sure that your last will and testament is in place is something that is a smart idea if you want to make sure that things can pass through smoothly. However, something that can be sometimes overlooked are beneficiary designations. And what's oftentimes misunderstood is that beneficiary designations will supersede the will, at least according to the accounts that they would be listed as. So, for example, if you have a 401k account or an IRA account, what you may end up having is beneficiaries that are directly listed on that account. Those beneficiaries would be the ones that would receive the payout at your death. Therefore, if you have two listed beneficiaries on your IRA and it's different than what you have on your last will and testament, the custodian will look to process the IRA with the two beneficiaries who are listed. And this can go for a number of different accounts. Retirement accounts are often the most popular, but there could be the case where you could have a transfer on death account. You could have life insurance policies or annuities, or bank accounts can even have a payable on death designation as well. Making sure that your beneficiaries match up with your last will and testament is usually a good idea. That way you can avoid any types of issues that could end up taking place after your passing. Passing by beneficiary can also offer some significant advantages, specifically that it avoids probate. Oftentimes, when you list the beneficiary on your account, it can be done seamlessly and quickly. Generally, all that the custodian would need is to have a completed death certificate and then just complete some paperwork to either set up a new account or however you're planning to distribute the funds. And this can be done in a rather quick way. However, if beneficiary designations are improperly listed or outdated, that's when things can be delayed and can cause some other problems. So a question that gets brought up is, who can I actually list as a beneficiary? And there are several different options that you can list. Some of the more common ones are a spouse or adult children. And you can list those, and generally all you need is some of their background information, have them listed, and there shouldn't be any type of issues with that. Now, if you are married and you list your children or somebody other than your spouse as a beneficiary, what could be required by the custodian is spousal authorization. So in other words, if I'm married to my wife, but I want to list my two children as the primary beneficiaries, and therefore I would not be leaving any funds to my wife, the custodian may require that my wife signs off on this and that she's aware that this is the case. Some families can consider this if both spouses feel like they're covered and they want to leave funds to their children at death, you just want to make sure that you're aware of what your custodian's rules are and what your state rule is to make sure that if there's spousal authorization that's required, you make sure that you get that taken care of. You can also leave funds to charitable organizations as well. And there can be some tax advantages if you're planning to leave a pre-tax IRA to a charitable organization, something that we've covered in previous videos. You can also leave funds to trusts, and generally these are done if you're leaving funds to minor children, because that trust would then be able to be managed by a trustee who could help that minor child and make sure that they're the ones that are not directly taking possession of this. If they're under the age of 18, it's not a bad idea to have a trust established, and therefore you can be leaving funds to that minor child. Oftentimes when you're setting up a new account, many applications, whether they be paper applications or online applications, will ask for beneficiaries. These beneficiaries are usually listed as primary beneficiaries and then contingent beneficiaries. Primary beneficiaries are exactly as they're stated. They're the ones who would receive the funds in the event that they're listed and you pass away. Those primary beneficiaries can be changed generally at any time. It just requires your authorization. Contingent beneficiaries, on the other hand, would kick in the event that a primary beneficiary predeceases you. So again, going back to the example I gave earlier, if I list my wife as primary beneficiary and my two children as contingent beneficiaries, if my wife and I were to pass away in an accident at the same time, our children could be listed as contingent beneficiaries. And since the wife has predeceased her children, at my passing, the children would become the beneficiaries in this case. This can be a significant advantage as well, because in the event that my spouse passes away at the same time, or if I don't update the primary beneficiary information, in that case, having the kids listed as contingent beneficiaries can also help avoid probate and make sure that on the contingent side that they're able to step up as the primary beneficiaries, and it can speed up the process in which the kids would be able to access the funds. Now, where this can get a little bit more complicated is the per capita versus per stirpes discussion. This could be involved when there's multiple children or next of kin, such as grandchildren, that could be receiving these. This is also something that you want to make sure that your custodian has on record as well, because depending on how you plan to break these out, this could have an impact on you leaving funds to grandchildren, disinheriting them altogether, which you may want to do or you may not want to do. Depends on what your wishes are. Let's first start with what some of these terms actually mean. Per capita means per head or per person. Many financial institutions actually default to per capita distributions. Therefore, in the event that I do have two children, and let's say my wife passes away before me, in that case, I list my two children now as primary beneficiaries. In the event that I pass away and I leave to them per capita, I am leaving 50% to my son and 50% to my daughter. Each of them would obviously take this at my passing. In the event where I have them listed as per capita, but what would happen is if, God forbid, one of my children would pass away before me, then my child who is surviving would become 100% sole beneficiary. So if my son were to pass away before I did, then my daughter would become the 100% primary beneficiary in this case. Let's use an example. So for Jane, she has a $300,000 IRA, and she plans to leave her funds to her three children, Tom, Harry, and Richard. In this case, they are listed as primary beneficiaries, and they are listed as per capita beneficiaries as well. If Tom were to pass away prior to Jane passing away, Harry and Richard would then be the surviving children. If it's a per capita distribution, instead of each receiving $100,000, which would happen if all three were living, Harry and Richard would end up receiving $150,000. Tom, due to his passing, is no longer included. Now, this may be a simple case and you may not have many questions here, but what about Tom's children? Well, if you list per capita, it could be the case where Tom is left out altogether and the two gentlemen, Harry and Richard, are left to split the proceeds entirely. Now, this could make sense in the event that you don't have grandchildren or a third generation to worry about. It could make sense in the event that one of the children do pass, that you want to make sure you leave it solely to the two survivors. But this could also get complicated when family dynamics become a little bit more complex. That's where the designation of per stirpes could make more sense for you. So per stirpes means per branch or per root, in which case it would extend beyond just the first generation. So instead of the $150,000 split between Tom and Harry, in the event that Jane had her account listed as per stirpes, that same 300,000 would be split three ways now instead of two. So it would be split three ways, but it would go to Tom's two children. And in the case that it was $100,000 each, the two children would split it then 50-50. So by splitting it 50-50, what would end up happening then is the children of Tom would still get the $100,000 share, while Harry and Richard would each get their $100,000. The per stirpes designation makes sure that Tom's children are not disinherited. And this can make sense in the event that you want to make sure that grandchildren are not disinherited. Obviously, it'd be horrible to have to deal with an issue where a child passes away before you do. But unfortunately, it is a fact of life that sometimes this can happen. This can also get complex, though, if you want to leave funds to grandchildren, but you don't trust a son or a daughter-in-law. You might need to have an other person listed as a trustee of the account. So making sure that you have the contingency plan in place if something were to happen, or that you trust a maybe son or daughter-in-law to take over as trustee for the grandchildren, is of the utmost importance if this is something that you're worried about. Other mistakes that can take place that are unfortunately somewhat common are from prior marriages, or in the event where you get married and don't list your spouse as a primary beneficiary. If you have an ex-spouse listed, technically speaking, it passes by beneficiary first, and that ex-spouse would be the one that could take claim of the 401k. So making sure that you have your wishes put on paper, both on the beneficiary side and on the last will and testament, is something that can make sure that your funds are passed the way that you would like them to be. You also want to make sure that you don't just change one account. If you just change one IRA, it doesn't necessarily change it across the board. By making sure that you can see this on each and every single account that you have, and if it would be on a life insurance policy, an annuity, or whatever else you may have, this is something that can make sure that your wishes are properly granted at the time of your passing. It's a good idea to move forward with the following type of cadence. Number one would be to gather all the accounts that you have and understand of how they pass by, either by beneficiary or by trust. If they pass by beneficiary, it's a good idea to take inventory of how you currently have the beneficiaries listed. If you have beneficiaries listed that are not up to your wishes, it's a good idea to contact your custodian or the advisor that you're working with and make sure you get the necessary paperwork to complete a new one. Once that's completed, you can submit it to the custodian and they should be able to take care of that. But while you're doing this, you may also want to make sure whether you have per stirpes or per capita listed as a type of beneficiary. Again, it's horrible to think that you could lose a child before you pass away, but this is a reality of life, and making sure that grandchildren are accounted for if that's what you want to do. It's important to make sure that the per stirpes or per capita designation is properly listed. From there, it's a good idea to make sure that you're reviewing this at least annually. And this can be done over a course of a couple minutes. If you get organized now and you have your system in place, you can check on this at least annually. And it's something that you can make sure, because as life changes, that you can adjust to it as well. Now, how you want to document this and communicate this to others is something that I think is a good idea to do ahead of time. But it's also understandable that this could be a case-by-case basis. Maybe you don't want beneficiaries to know about this just yet. Regardless, death is a reality of life, and making sure that you have a plan in place to pass this along to the next generation when that day does come is something that is in your best interest to take care of. The part in this that is something that I always come back to is that this could take minutes to complete. Maybe it could take a little bit longer, but regardless, it's not something that should take super long. Having it done properly, though, can save your loved ones and the ones you want to leave this to hours upon hours of time, especially in the event that this person is grieving your passing. By having this in place and communicated ahead of time, you can save yourself a ton of time and save your loved ones a ton of grief. But doing this in a way that is organized and communicated ahead of time is a good idea to do while you're still living. At your passing, there's not much you can really do to fix this. And if you haven't yet subscribed, take some time to do so now, because we cover things that are focused on retirees and the many problems that they face. And speaking of retirees and the problems they face, one of the most critical times for a retiree is what's known as the retirement red zone. If you're unfamiliar with it, check out this video right here to have a better idea of how it breaks down and how you can make sure that you're making the right decisions.